I'm Kate Cronin-Furman. I'm one of the panelists. I am a human rights lawyer and political scientist by training, and I work on mass atrocities, studying them, not committing them so much, and also the politics of international and transitional justice. So over the last 2 years, I've made 4 trips to Sri Lanka, which is one of the case studies for my book project that I'm working on right now. I also work in Congo and Cambodia, and I'll be talking today about kind of the history of accountability politics in Sri Lanka.
Great. I'm Beth Hancock. I'm with the law school, and I've also been a human rights lawyer and now full-time professor of international human rights and transitional justice. Before coming to Stanford, I was in government, and the office that I headed was one of the points of contact with the Human Rights Council in Geneva, which Kate is going to talk a little bit about, but was really, Sri Lanka, I think, is very much a success story for that institution, which has gone through several permutations over its life. And so it's a great case study of the role that external pressure can have on trying to bring about transitions internally. And now I teach over at the law school. And I'll be talking a little bit about one of the proposals that has emerged from this Human Rights Council process is the idea of a hybrid tribunal. And so I'll talk a little bit about what the continuum of hybridity is and where this particular effort might fit along that continuum and what some other models are. And Lee Ashley can actually speak a lot about East Timor, so maybe she'll weigh in a little bit during our discussion.
Hi, I'm Bhavani Fonseca. I'm a human rights lawyer working in Sri Lanka with a think tank called the Center for Policy Alternatives. And for the last 12 years or something, it's been very much documenting, litigating on human rights violations, and also working on the Human Rights Council work, which resulted after several years in the adoption of a resolution, which was co-sponsored by the government of Sri Lanka, so it's historic. But I'll be also talking about what next in terms of the changes in Sri Lanka and what the government has promised and what the space is for civil society and others to work in this one.
Okay, as both Beth and Bhavani have noted, we just had the Human Rights Council resolution last month, which is fairly historic. After years of contention between Sri Lanka and the Human Rights Council, this resolution was adopted by consensus, and Sri Lanka was actually a co-sponsor on it. And as I'm sure we'll be getting into, what the resolution actually requires is still up in the air, but at the very least it does commit Sri Lanka to undertaking a domestic transitional justice process with some international involvement and oversight. So to kind of give you a flavor for why this is such a historic moment, I want to kind of rewind the clock back and talk about what the interaction between Sri Lanka and the international community over transitional justice has looked like for the last 6 years. So as many of you will know, the war between Sri Lanka and the Tamil Tigers ended in May of 2009. And in the last few years, it has become fairly clear that war crimes and crimes against humanity were committed on a massive scale, especially in the final phase of the war. There's evidence that the government undertook intentional shelling of hospitals and declared no-fire zones. There's actually video evidence that was taken by members of the military that shows torture, rape, and extrajudicial execution of surrendered combatants. And today there's still tens of thousands of people who are unaccounted for. It's worth noting that the rebels are also implicated in widespread violations of international law. So they committed extrajudicial killings as well, along with forced recruitment and widespread use of child soldiers. Now, from the earliest reports of these atrocities, members of the international community have pushed for accountability. So, domestic human rights organizations, international human rights organizations, and also Western governments have been calling for justice for these crimes. But the post-war government, and that's the Rajapaksa regime, refused to either investigate or prosecute these allegations. This isn't really a surprise. We know that the perpetrators of mass atrocities don't prosecute themselves. Why would they? And in this case, there's very high-ranking individuals implicated in these crimes. For instance, the president's brother is actually believed to have affirmatively ordered the assassination of surrendering combatants. And even if regime leaders might have wanted to kind of throw some mid-level guys under the bus to get the international community off their back, that probably wouldn't have been possible for them. So the military became extremely powerful in Sri Lankan society on the strength of its victory. At the end of the war, it was about 100 times larger in terms of manpower than it had been at the start. And the defense budget has actually increased every year since the war's end, despite the absence of any defined threat to the country's security. Add to that the fact that the allegations of atrocities are widely disbelieved among the majority, and that's the Sinhalese population, particularly in the south. To them, the military are heroes. And that's because they defeated this brutal terrorist insurgency, which for many people in the South had inflected their lives with fear for decades. The result of that is that many people do believe that the evidence of atrocities is fake. So I've had numerous people tell me that the cell phone videos, which have been verified repeatedly by forensic experts, are shams, that those are actually Tamils dressed up in Sri Lankan army uniforms to discredit the military. And I don't think they're lying. I think people genuinely believe that to be the case. So kind of the upshot is that among the majority population, they either do not believe that atrocities occurred, or they believe that whatever may have happened, and they don't want to look too closely at it, was probably worth it to end this war, which had been such a problem for the country for so long. Now, of course, there has been sustained demand from the victim population, from Tamils, for justice over the last few years, but they're only about 15% of Sri Lanka's population, and they were not part of the Rajapaksa regime's constituency, so their demands effectively did not matter. And the upshot is that in the absence of any politically relevant domestic demand for accountability, and the presence of government culpability for war crimes, Sri Lanka's response to pressure for transitional justice was hostility, accompanied by accusations that the international community had a neo-colonial agenda. But there's also a little bit of what I would call a strange schizophrenia to their response. So there was this adamant denial of war crimes and an insistence that this war was conducted with 0 civilian casualties, which is on its face false. But alongside this insistence, there was a proliferation of weak domestic mechanisms accompanied by sort of rhetoric about the exhaustion of local remedies and complementarity. Which is quite interesting because Sri Lanka is not a member of the International Criminal Court, which is where the complementarity idea comes from. So every time international pressure kind of ramped up and reached a crisis point, the Rajapaksa regime would respond with the creation of one of these weak institutions, tangentially linked to accountability, but never actually offering the possibility of justice for war crimes. So we saw this for the first time in 2010. The UN Secretary General impaneled what he called a panel of experts on Sri Lanka, and he asked them to investigate 2 things. First, whether there was credible evidence that violations of international law had occurred in the final days of the war, and second, whether there was any domestic mechanism undertaking an accountability process. So Sri Lanka was, of course, furious about this and immediately protested it as an incursion on their sovereignty. But they also announced the creation of something called a Lessons Learned and Reconciliation Commission. And when the UN panel issued a report, which actually argued that Sri Lanka's conduct of the war was, quote, a grave assault on the entire regime of international law, Sri Lanka said, no, hang on, we have a domestic process working on this, and you're going to have to wait for their findings. Now, that report came out, and while it was actually quite strong on a number of human rights issues, it barely touched the question of accountability, and its conclusion on allegations of international crimes bore no resemblance to the UN's. So it exonerated the military entirely and said that the protection of the civilian population had been given the highest priority. We saw something very similar about a year or 2 later, in late 2011 and early 2012, as pressure for a UN human rights resolution creating a commission of inquiry ramped up. Sri Lanka created an Army Court of Inquiry. Now, this body was ostensibly going to investigate allegations of war crimes, But the minute the Human Rights Council was over, they concluded that there were no credible allegations worth pursuing and closed up shop. Similarly, when UN Human Rights Commissioner Navi Pillay announced a visit to Sri Lanka, which occurred in the summer of 2013, Sri Lanka announced a commission on disappearances, which we'll be hearing more about later, I'm sure. But at the time, people felt very strongly that this was simply a gesture in the direction of getting the international community to let them go already. And again, in late 2013, when UK Prime Minister David Cameron issued an ultimatum in advance of the 2014 Human Rights Council meeting, Sri Lanka announced both a census of war deaths and then started exploring the possibility of a truth commission with South Africa. So for me, this looks like a very interesting call and response pattern between international pressure on the one hand and these sort of sham or at most weak institutions on the other. And it's important to note that every one of these institutions was met with both skepticism and criticism from human rights activists within the country, human rights advocates outside the country, and US, UK, Canadian governments. But elsewhere, the reception was different. So Sri Lankan rhetoric about domestic remedies and about sovereignty and neocolonialism accompanied all of these institutions. And to me, it looks very clear that that was targeted at other members of the developing world. So in 2013, President Rajapaksa delivered a speech at the UN General Assembly in which he decried international interference in the internal affairs of developing countries. And this was kind of a consistent refrain from the Rajapaksa government over the last few years. And the public debates at the Human Rights Council show that this narrative really penetrated pretty deeply among other members of the developing world. So at the 2014 session, which I actually sat in for, so this is based on my own observations, a number of states explaining either no or abstention votes on the resolution parroted the Sri Lankan homegrown methods rhetoric. And it appears that they were fairly successful at convincing similarly situated states to support them against imperialist human rights and accountability pressure. Now, at that 2014 Human Rights Council session, an international investigation was finally impaneled. But Sri Lanka had actually managed to delay that for 5 years. And that's time that they had to destroy evidence, to bulldoze mass graves, to intimidate and disappear witnesses, and actually to appoint accused perpetrators to diplomatic posts where they would have immunity from prosecution. And when the investigation was announced, the Rajapaksa regime, of course, rejected it entirely. So they barred the investigators from entering the country. They had to do all of their work from outside. And they announced the proscription of a number of Tamil diaspora organizations, which was presumably an attempt to prevent them from gathering information and facilitating its flow out of the country. And actually, in the run-up to the 2014 Human Rights Council resolution, there were rumors that a new unit of the police had been created, especially to monitor people who might be passing information about human rights conditions out of the country. And 2 very high-profile activists were arrested at that time, and it appeared that the regime was preparing to detain them indefinitely under the Prevention of Terrorism Act, although there was quite a lot of international outcry, and they were eventually released. So this very hostile stance was basically the status quo until something unexpected happened, which was that last year, Rajapaksa called an early presidential election. And this looked like an attempt to consolidate his hold on power. So he'd been in office for 10 years at this point, and in that time, his regime had undermined Sri Lanka's very old and very previously solid democratic institutions, really beefed up the office of the executive presidency. He consolidated power in the hands of family. So one of Rajapaksa's brothers was the Secretary of Defense, another was Speaker of Parliament, a third was a cabinet minister, and a number of sons, nephews, hangers-on were in other positions of power. The media and the judiciary were effectively hamstrung. Civil society was repressed, and in many cases, people were actually subjected to public threats by members of the government, which is a pretty amazing thing if you're coming from the Western world. The situation was, of course, particularly bad for the ethnic minorities. So for the Tamils living in the post-conflict zone, the military was heavily deployed, ostensibly as part of development efforts, and indeed they did build roads and other things, but also as a major surveillance effort, which basically put the entire population on lockdown in the aftermath of the conflict. For Muslims living in Sri Lanka, Rajapaksa rule meant tacit state support for militant Buddhist violence. So there were devastating intercommunitarian riots in Alufgama last year, which led to the deaths of 4 people, the displacement of 10,000, I believe, and the government reaction was to impose a media blackout and accuse journalists who reported on it of fostering disharmony. So obviously not a great situation, to say the least, but nevertheless, with the expectation that Sinhala Buddhists would support Rajapaksa, most observers believed that he would walk into a 3rd term in office and find some way to become president for life. But then he was blindsided by an announcement that his former friend and health minister, Maithripala Sirisena, would be contesting against him. So Sirisena ran on a good governance platform. He, despite his fairly impeccable Sinhala Buddhist credentials, received the support of Sri Lanka's minorities, who presumably felt that anything would be better than Rajapaksa, and critically got a number of Sinhalese, former Rajapaksa supporters, on the issues of cost of living, which have been rising in Sri Lanka over the last few years, and official corruption, which was really quite fantastic at the time. So Sirisena is brought into office. The election immediately brought a number of changes, which I'm sure Bhavani will tell us about in detail, but it was not clear what the implications would be for accountability and transitional justice. So a number of people who are implicated in these atrocities remain in positions of power. Sirisena himself was actually the acting defense minister in the last days of the war. And the military is a very important part of this unity government's governing coalition and remains heavily deployed in the north. Nevertheless, over the last 8 months, or more than 8 now, 10 maybe, this government has embarked upon a turn back towards the West. So Sri Lanka formerly had very good relations with the West and with India. In the aftermath of the war, turned towards China, which obviously doesn't impose pesky human rights conditions on the delivery of loans for infrastructure projects. And with this turn back towards the West, there have been a number of indications that they are willing to move on human rights issues that were previously an absolute no-go under the Rajapaksas. And of course, one of these is this co-sponsorship of the resolution. And I'm going to wrap up here, but I do just want to say this resolution is a very historic moment, but at the moment, it is not clear what exactly it requires. And the question of semantics has become a very important issue over the last few weeks. So what the resolution says is that Sri Lanka must undertake a domestic mechanism and that there should be international involvement from experts, judges, prosecutors. And right now what's happening is a debate over whether this means Sri Lanka must have a hybrid judicial process or whether Sri Lanka is undertaking a purely domestic process with assistance from the outside. So hopefully Beth can tell us whether there's any meaning to this distinction between these 2 options and indeed what the continuum looks like.
What the options are. Well, that's great. That's very helpful. So this idea of transitional justice is a field that has emerged really starting, I think, in the sort of 70s when the Latin American countries began to emerge out of situations of authoritarianism into more of a democratic transition. This idea of addressing crimes of the past and repression of the past became sort of paramount in people's minds, and it really encompasses a whole range of mechanisms and sort of interventions that can be done, dealing with persons who are disappeared, reparations, the rehabilitation of victims, accountability issues, truth-telling, memorialization, et cetera. And all of these are sort of in play right now in Sri Lanka, and I think Bhavani can sort of catch us up on where some of those mechanisms are. I will focus a little bit on this accountability question because there is this very curious language in the resolution, and by virtue of co-sponsoring that resolution, Sri Lanka has essentially undertaken an international obligation to implement that language. Whatever it means, it's got to implement that language, which is historic and unprecedented. So often, these resolutions are either not by consensus, where there's a large number of states that defect, and so it just doesn't carry the legitimacy or the power that it would otherwise. And the implicated state rejects it, and so you're in almost a stalemate happens, where you have great language in a resolution, but no commitment on the part of the target government to actually implement anything in there. Here we're in a situation where we not only have consensus of the Human Rights Council, such as it is, we also have the agreement of Sri Lanka, and those two go hand in hand. There are many states that will only join a resolution if in fact the target state is in agreement with it, and that's their sort of a nod to sovereignty. So China, for example, in the General Assembly or the Security Council will often look to the target state to decide whether or not they're going to support a resolution or not. So when it comes to this question of hybridity and what are the options, if you remember back, the whole field of international criminal law really emerged in full force in the post-World War II period. There were, of course, antecedents, and war crimes have been prosecuted since human societies have been at war with each other. But the idea of an international tribunal really came to the fore in World War II. But then, of course, the Cold War set in, and those ad hoc tribunals that were formed to deal with a particular conflict. We had the European theater at Nuremberg, and then we had the Tokyo Tribunal that dealt with the Pacific theater, crimes that were committed in the Pacific theater. Those two finished their work, closed their doors, and nothing happened for almost 50 years. And it was not until the end of the Cold War, when the Security Council began to function again as an executive body for the United Nations, that a consensus was able to emerge that we should revisit this idea of accountability after the commission of grave crimes. And it was first the war in Yugoslavia, the dissolution of Yugoslavia, and then the genocide in Rwanda. The international community created what can be called international tribunals. So they were subsidiary bodies of the United Nations. They had funding from the United Nations. Their staffing all came through the United Nations. The prosecutor, for example, was deemed at the status of an Undersecretary General of the United Nations. So they were truly international bodies. Those two tribunals started their work, and then of course we had additional situations emerge of armed conflict and repression. So we had East Timor after the referendum in 1999. We had Sierra Leone that had a brutal civil war. We had Cambodia, which had experienced crimes against humanity in the end of the 1970s, where there had been no accountability, so an exercise in historical justice. And advocates and others within the international community began to say, well, we need more international tribunals. We've got Yugoslavia, we've got Rwanda, but what about East Timor, what about Sierra Leone, and what about Cambodia? In the end, a sort of tribunal fatigue had set in at the United Nations. The Yugoslav and Rwanda tribunals proved to be quite expensive. It took a long time to set them up because they were standalone international organizations. They were moving more slowly than people had anticipated, in part because the law was new. They had to build their staff, they had to find defendants, they were at large. The ICTY, the Yugoslavia Tribunal, worked for several years before they had a full docket of cases moving forward because the defendants were being protected by the regimes in place. And so this fatigue set in, and the international community began to look for different models of how to bring about accountability with international involvement without having to create a separate standalone institution. And so in Sierra Leone and in Cambodia, a new model emerged where essentially a treaty was drafted between the UN, generally negotiated by the Secretary General, and the target state, where the agreement was made to create an international tribunal. In Sierra Leone, it was a fully international body, but it was done with the consent of Sierra Leone. Some of the staff were Sierra Leonean, it was in a Sierra Leonean building, it was under Sierra Leonean rules to a certain degree, Sierra Leonean law to a certain degree, but there were also international components that were built into that tribunal as a standalone tribunal. In Cambodia, it was ultimately Cambodian legislation that brought about what are called the extraordinary chambers. Technically, they are still part of the Cambodian judicial system, but they stand separate and apart from the rest of that judicial system. They're governed by Cambodian law that has included and infused elements of international law. And again, the staffing is hybrid, so they have an almost extremely strict formula where every key position has a co-prosecutor or a co-investigating judge, which is been, as it has proved to be, a sort of recipe for inaction, because the Cambodian party still has ties to the Cambodian government and has often served in a sort of obstructionist role vis-a-vis the international party that has been pushing for additional indictments to be brought or additional counts to be brought. And there really was no mechanism in place to resolve disputes between these two equally sort of authoritative parties within that system. So that's not a model we necessarily want to reproduce in further mechanisms. But it was an experiment, and an experiment that has proven to be quite costly and time-consuming and really kind of slowed things down there. In East Timor, we had a different situation, and a similar model has been employed in Kosovo, where you had what was essentially a failed state, or a proto-state that had reemerged from this situation of essentially colonization by Indonesia, had very little in the way of domestic infrastructure, although there was some. And the UN essentially stepped in and had a trusteeship over East Timor, with the idea of eventually transitioning it to independence. And as part of that trusteeship, the UN exercised all legislative, judicial, and executive functioning. So as part of that trusteeship, they created these special panels, which Lee Ashley worked on, in order to deal with crimes that had been committed in the post-referendum period. Kosovo, very similar. Kosovo had not yet been, their independence had not yet been recognized, but it was on a path towards independence, and the language in this trusteeship sort of mandate documents talks about the eventual status of Kosovo. There was this idea that it was moving in that direction, although the international community didn't want to sort of prejudge the eventual outcome that in fact did come to pass. Once again, it was the UN that was exercising the sort of tripartite powers of what we would think of as governmental powers. And they too created these special panels to deal with war crimes issues. And because the UN was in charge, they could sort of draft all the legislation necessary. So they incorporated international crimes and made those justiciable within these special panels. They allowed for foreign judges, prosecutors, defense counsel, administrators, investigators, personnel generally, to be embedded within those systems. And rather than do this sort of co-prosecutor, co-this and that, they were teams that were made up of a combination of local and international personnel. And the theory behind this hybrid model, separate and apart from this international model, was that you'd have technology transfer and knowledge transfer. That by having international quote-unquote expertise working alongside local actors, you would teach people, and there's a little imperialism sort of implicit with this, but you would teach people how a proper functioning judicial system works, with the idea that those skills and knowledge, et cetera, would bleed into the ordinary criminal justice system. And so some of these special panels have been very much operating side by side with ordinary criminal courts, and there's a lot of kind of a revolving door of staff back and forth. Other models have been a little bit more siloed, sort of standing alone, and there's been less of this ability to do kind of technology and knowledge transfer. The model works when the internationals approach the job with a degree of humility, with an open-mindedness, with a lot of knowledge about how the local system worked, how violence worked within the particular society. They don't work when the internationals come in with a sense of sort of, we're the experts, listen to us, I'd like some more coffee. That's not a model that works well. And we've seen variations of that over the years with different personnel, of course, bringing different things to the table. Moving sort of down the line on this continuum towards, at the other end of the extreme of this continuum is, of course, a purely domestic system, which has its pluses and minuses and has worked in some places. Argentina, for example, to the extent there's been accountability for the crimes committed in Argentina, it was purely a domestic effort. You had the domestic capacity to do it, you had the political will to do it, you were able to change your legal framework in order to enable those trials to happen, et cetera. But moving down this line, Bosnia offers a really interesting model and is one that has been talked about as a potential source for some ideas for Sri Lanka, where in Bosnia you had specialized chambers where the war crimes cases emerging from the dissolution of the former Yugoslavia were prosecuted. The idea was that the Yugoslavia tribunal, the sort of international tribunal sitting in The Hague, would handle the big fish, and the smaller fish would be handled by these more local courts. Law was drafted that enabled foreign individuals to be embedded within that system. But the ratio of internationals to domestic personnel evolved over the years. So in the beginning, many of the panels were a ratio where there were 2 international judges and 1 domestic judge. And then at the appellate level, 3 internationals and 2 domestic. In the interim, that ratio flipped. So for a while, there were 1 or 2 internationals for 3 or more of the domestic. And then eventually, there was a sunset clause that kicked in. And all the internationals stepped away. For a while, there was one guy, it was an American, he was like the last holdout in the system, David Schwendeman, who was the last one standing in that system. Now, my understanding is that Alina has been there more recently, but it's purely domestic. It's all domestic personnel, defense counsel, prosecutors, judges, staff, administrators, et cetera. But there was this interim period where you had international expertise there that not only provided this sort of knowledge and modeling good behavior, et cetera, but also offered a window into the system and a sort of check on a return to corruption, a return to selective prosecutions, due process violations, et cetera. The idea was that the international community was setting a sort of a standard almost of what we expect to see, and that by virtue of embedding these internationals, you would avoid some of the pitfalls. Now, in Cambodia, for example, we saw that that didn't always work. There was one international co-investigating judge who became very close with the regime and seemed to be essentially co-opted by the regime. I'm sure you've looked at this particular case, you know what I'm talking about. And so didn't play the role that it was expected that the internationals would play in terms of lending legitimacy and keeping the system kind of fair and even-handed going forward. Bangladesh, also in the region, offers an interesting object lesson, really, for what to do. They created, emerging from the War of Liberation in the 70s, they also exercised a historical justice enterprise, created the International Crimes Tribunal, which is really international in name only. They do adjudicate international law, but they have not allowed any international personnel. Some defense counsel tried to represent defendants before that tribunal, but Bangladesh has made it very difficult for them to do so, including sort of manipulating like bar rules, for example, where you have to be a member of the bar in order to appear before the Bangladesh International Crimes Tribunal, but only Bengalis can appear before it, so you have these very onerous rules. And so, yes, of course, we'd love to have international assistance, but you have to satisfy our bar rules, and then of course you make the bar rules impossible to satisfy for a foreigner. Defense counsel there have been harassed, they have been detained at the border when they've tried to come in, even if they're playing a sort of support role, backbenching Bangladeshi defense counsel, there have been issues with respect to defense counsel there. So, you know, that claims to be within the tradition of this international crimes, Nuremberg, et cetera, and yet it's really very much a perversion of the values that were inherent to the Nuremberg process. And so, you know, where would Sri Lanka fit along this continuum? You know, my understanding from Bhavani and others is that anything that sounds like an international tribunal is politically not palatable. That's not what's expected, and frankly not even in the language, really, of this resolution. So we're in this zone of hybridity, and, you know, to what extent, you know, are we going to have majority foreign judges versus minority foreign judges? Are foreigners just advisors in some capacity? So the Iraq High Tribunal that formed after the fall of the Hussein regime, that was the model that was employed. It was mostly Americans, although it was a coalition, so there were some other Commonwealth. Yeah, don't forget Poland. I'm sure had a lawyer floating around there somewhere, playing a very much of a backbench kind of a role in assisting with that. Sri Lanka has had a number of these commissions, which we talked about, that have had international advisors associated with them. One group of international advisors basically disbanded themselves after a year because it was clear that they weren't really meant to be international advisors. No one was taking any of their advice, and they were just providing cover, essentially, for what was to be a pretty empty institution. And then more recently, there's been another set of advisors that have, I think, probably done some good, but there's also a concern that they've been somewhat captured by the regime and are essentially churning out sort of memoranda that seem to support rhetoric about the way in which the war was waged and who was ultimately responsible and this and that. And so their role has been somewhat controversial. There's other ways you can hybridize an institution, and so one of them is by incorporating international rules into the domestic system. Sri Lankan courts have not been a force for good when it comes to accountability and human rights violations emerging out of the war. And so there's a lot of distrust of that institution, and in some respects the rules have been twisted in ways that are not helpful for adhering to due process principles. And so in some of these hybrid models, the judges have been empowered to draft their own rules, and so when you have internationals involved, they can bring international human rights perspective to that drafting process. Sri Lankan law, my understanding, does not include genocide, crimes against humanity, or war crimes in the actual penal code. Of course, they can prosecute acts of murder, torture, mistreatment, but if we want to call them international crimes, we need to amend the penal code in order to enable that. That has the potential to raise some ex post facto problems, right, because the law was not in place at the time the defendants acted. The Sri Lankan Constitution, however, is consistent with the International Covenant on Civil and Political Rights, which is a human rights treaty, that says generally we have the ex post facto prohibition, the protection against ex post facto prosecutions. However, if what you're doing is prosecuting crimes that were criminal under international law at the time the defendant acted, that does not run afoul of the ex post facto provision. And the Sri Lankan Constitution, miraculously, that's an adverb, I don't think it is, but it should be, as a miracle, actually includes the exact same language within it. So there would be no problem with drafting a new statute and then having it apply backward to conduct that happened during the period of the armed conflict. So maybe I'll stop there and we can take up more issues in Q&A, but maybe you can kind of catch us up on where things are.
And it's good that I'm going last because I don't have to do the introduction, and I think Kate kind of mapped out what we've kind of faced in the last 10 years. So just a quick look back, I mean, the picture was very bleak under the Rajapaksa regime. And as human rights lawyers and activists, what we had was a time where we were constantly under surveillance and threat, and to a point where even in the Human Rights Council in Geneva, which is like a UN body, we were threatened and screamed at by the government. So it was very much a very difficult time to critique and comment and challenge the government and what was happening. What's happened since 2015 January is at least a recognition very bad things happened during the war, and there has to be an independent investigation by the Sri Lankans, and they're very clear this has to be a very Sri Lankan driven process, with the support of international actors. And this is what we're trying to figure out right now. In January with the elections, what's happened is also a change in how Sri Lankans look at what's happening and what's happened. And also space to have an open conversation. This was not there before. So just to give you an idea, Kate mentioned about the past commissions. We've monitored several of these, and we had about 13 commissions of inquiry in a space of 10 years, which has not led to any convictions, and these are presidential commissions of inquiry. We didn't also have a single conviction, though investigations have been carried out, of serious violations. So there's been a real culture of impunity, and perpetrators have actually have gone free and really been able to do anything they want to because they think they can get away with it. So that's kind of the scenario, and we have a range of violations that have been now documented by the High Commissioner's investigation. So what's good with the High Commissioner's investigation, it confirms what we've been saying for years. But as civil society, our standing is different to a UN investigation. So the High Commissioner's investigation was a human rights investigation. He was not allowed to come in. So it was very much testimony from people who fled Sri Lanka, but also Sri Lankans who were brave enough to go and give testimony. So it's not just an external thing. People did engage. We engaged. So the High Commissioner's report that came out in September during the council session was very clear. There were violations from all sides, from the government forces, from the rebels, as well as paramilitary groups. And that the documentation indicated there has to be further steps taken. And his recommendations are very specific. There has to be a hybrid model on accountability. And the whole question now is, what is hybrid? And there is a debate, the hybrid, it's the H word now, it's the bad word. And everyone's like, what is hybrid, what does it mean, is it internationals taking over? And our position as Sri Lankan lawyers and civil society activists is, we are asking for the support. We're not letting internationals control it, but we need the support because we've had such problems in the past. We haven't had a functioning legal judicial system. Just a note on the side is we've had the first female Chief Justice impeached in 2013 because she actually went against the Rajapaksa government in a case we filed in the Supreme Court. So there was really no space to even use the judicial system to challenge, let alone politically challenge. So the judges were politicized, the Attorney General's Department, that's a state council's institution, that's politicized because appointments were done by the president. So you have institutions which are very much controlled by the government of the day, and some of whom are still in government. And with the new government, what we had is, so we've had two elections this year, the presidential in January and the parliamentary elections in August. And through the ballot box, and this is the difference in Sri Lanka compared to other transitions, it was a peaceful transition. There was no blood let out this year. It was very much people going, and I monitored elections, large interest, 80% turnout in elections, people going and saying we wanted a change. And the change meaning they couldn't articulate it, but change in democratic governance, accountability, and a whole range of things. So the government came up with their own proposals to Geneva. I mean, Geneva is the Human Rights Council. And the foreign minister's statement, which was backed by the prime minister and the president, promised specific initiatives. One was a court system, accountability. One was a Truth and Reconciliation Commission. Kate mentioned that. Office of the Missing, because we've had thousands of cases of disappearances. Amnesty International says 80,000. We think it's much more because there hasn't been an investigation really. So Office of the Missing Person and an Office of Reparations. So 4 major mechanisms. Legal reform, security sector reform, and a range of, it looks good on paper, and everyone was like, great, at least we have now a government that says there has to be change. What happened in September it's not just a historic moment, it's a great opportunity for us to also really think about what's been happening, was the government not just co-sponsoring, but committing in the international community, the UN Human Rights Council, that they will commit to certain measures in Sri Lanka within an 18-month period. So the resolution provides a time frame. The High Commissioner has to report back to the Council in June 2016, and there's a comprehensive report in March 2017. That doesn't mean everything needs to be done at this time, but at least it gives a time period for also us to look at what's happening. So we now have a resolution, we have government promises, but we also have a change in Sri Lanka in terms of recognizing there were bad things that happened, but also saying, look, we need to correct certain things. So this week itself, we had a very major anniversary, which is the 25 years of the eviction of the Muslims from the north, which is thousands of the Muslim community in the north were evicted by the rebels. Very important because it was just a mass-scale eviction of people, and it's had a huge implication for people from even now who are questioning their identity, where do they belong? But also the government tabling 2 past commission reports. So out of the 13 commission reports, only 1 is public. 1 was public, 2 have been made public this week. 1 is the Missing Persons Commission that Kate referred to, which we've monitored, and the other one is called Udalagama Commission. As civil society, we monitored both processes, and we commented that they're flawed from the inception, the framework, but also it was extremely politicized, the appointments, the way it was conducted, and how people were threatened who came to give evidence. So huge problems at the different levels. But at least now the government has recognized that we need to remember certain events like the eviction, like certain massacres, but also table public reports. And we've critiqued these reports on what we've seen, but interestingly, the reports actually now point the finger at some of the security forces as well. So the presidential commissions themselves says certain acts, like mass killings, happen from the security forces. So it's not civil society or the UN saying crazy things. It's the government's own commission saying. Now these are all certain investigations that had limitations. So what we say is these things have happened, but we need a comprehensive investigation that leads to accountability. But that's the status where we stand. Now with the government's promises, it's about what next and where do we go, where do Sri Lankans position themselves, or do they, do they just come in from the outside? With the court, they haven't really indicated again what Beth mentioned, the numbers. Where would the foreign judges sit? Already the certain sections of the government says foreign judges and lawyers cannot work in Sri Lanka. We are contesting that, saying, there are certain procedural things that can be done, but this is possible. The government has also promised a new constitution next year. So we're saying, look, transitional justice, constitutional reform falls within the 4 pillars of transitional justice. You can have provisions that allow for international judges, lawyers, investigators to work in Sri Lanka. It shouldn't be a mechanism like the IJAP that Beth referred to, where internationals just come and advise, but their advice is not taken on board. It has to be robust involvement. So what we're doing at the moment is really talking with the government, and that's a big change. We earlier couldn't talk with the government. Talking with the government and actually influencing the design of mechanisms, but also influencing the legal reform, the laws that require these mechanisms and the crimes to be in place. So we have to, it's really a new phase, and we have to see where it goes. But we're starting from scratch, really. We don't have individuals who are expertise in particular areas. So we're really looking at individuals who need training, new laws, new mechanisms. The TRC, again, it's to be seen what it can be, but with a culture of commissions that have really led to nothing tangible for the victims, it's also managing expectations. The victims, mothers of the disappeared, witnesses of horrific crimes have gone before so many commissions, many under threat, and for them to repeat what they've seen, what they've witnessed, what they've experienced is going to be another torturous journey. So we also have to think about how is this going to correct certain flaws from the past. The government is looking at the South African experience. We as civil society are hesitant with the South African experience. We keep saying, look, there are other models that are better, that are new. Let's look at some of the Latin American experiences, for example, Peru, Argentina too, but Peru is a much newer case. But also some of looking at local ways of getting to the truth. It doesn't always have to be just one state initiative. So truth-telling really can be multifaceted, and we have to really get to it. Again, a new area. The 2 areas I think are much more clear-cut, which won't take too much time to set up and implement, is the Office of the Missing that the government has promised, and the Office of Reparations. And reparations meaning compensation, land, return of land. And on that, we've had some success this year. I've been part of a legal team litigating on some of the land grabs in the North and East. And after 10 years, the government actually released some of the land, and people have gone back. Small scale measures, but at least give some confidence that at least it takes time, but at least we're in the right track. With the Office of Missing, again, the ICRC is involved. We'll have to see how that follows through, but I think at least the right to know could be addressed if the mechanism is done right. Now, who again is going to be part of these mechanisms, we're yet to know, but we're pushing for active participation of civil society and victim groups. understanding to be represented by lawyers or by the groups itself in these different mechanisms. So that's broadly the initiatives government has promised. From the civil society perspective, what we are worried is really, as I mentioned, the expectations. All this has been promised in 18 months. What is possible? And with the coalition government, with those who are part of the previous regime, it's a recipe for a disaster in a way. But it's also an opportunity. I mean, we are at the moment actually shaping a new Sri Lanka, possibly. So it's also trying to see the positive side of it. But it could be messy, it could be incomplete, it could be contentious. It could be a battle where people say this happened, this didn't happen. So it's also the space to have that debate. What's important though is to have the transparency, because people actually, as I said, they don't even know what Geneva means. What did Geneva lead to? What does hybrid mean? So to explain what these mechanisms are, what it could mean, why it could be different to all the past failures, that's very important. But to also look at, I mean, a lot of people are very excited about courts, council, laws. I mean, it becomes very legal. I mean, as a lawyer, I also get excited with the legal aspects. But it's also the human dimension. It's about the victims who experienced it. It's about villagers coming together and having a conversation. So even with the 25th anniversary of the elections, there's still a denial among certain people it happened, or a denial to recognize the impact of such evictions. It's also important to look at other ways of getting to a transition, to reconciliation, to look at psychosocial issues. I mean, I keep debating this with even lawyers, that we need to have the psychosocial aspect ingrained in a court system, ingrained in ARC, because if you're expecting people to come forward, it's very important to have the protection and the psychosocial aspects. So those are the arguments, debates, conversations happening. It's an opportunity, but it's also an opportunity that we have to be responsible in how we move forward and to be realistic. I keep saying I think we're going to have certain things move next year, but it could get delayed, and then not to get frustrated. I mean, Argentina, it's taken 30 years and it's still continuing. Cambodia, it took 30 years to even get to that phase of it, you know. And we're doing it in less than a decade after the end of the war. But there is an impatience as well in Sri Lanka that there are mostly majority communities saying, why are we even talking about it? This is the past. We now have a peace. The minority community is saying there's no point having these domestic mechanisms. It should be the ICC. It should be an international tribunal. So it's quite exhausting managing all these debates, let alone the expectations. But I think, end of the day, what we keep thinking is, if it's going to be a new country, a new Sri Lanka, a new vision, it's going to be a hard road. I mean, if you think about all the transitions that have happened, and it's not going to be a clear-cut solution. We're going to have debates, we're going to have a lot of disagreements. But what is the legacy we leave behind is also something we need to think about. And that's also going to be contested. What is the legacy? So I think I'll leave it at that, because I think I've raised a lot of questions. But as Sri Lankans, I keep saying is it's very important to look at what can be done within Sri Lanka. We can have the debates in Berkeley and in Stanford, in Geneva, but it's very important to do it in Sri Lanka now. Thank you.
Very interesting, the three panelists, and I just want to make a comment and a question, like coming from Argentina, and then before coming to Stanford, there was a group of Sri Lanka that went to Argentina to study the process of justice, and we wanted to take some ideas to take back to Sri Lanka. And okay, we discussed all the transition also. My question here is, it's not most of everything matter of time, because in Argentina, like, after the transition, it was the only country in Latin America. The transition was like collapse. Like after the war, like the military lost all their power. Like the civil society getting power. They started all the process, the judicial process, but have to stop it because even if they lost the war, they were very weak. Many people started to get threatened. The president started to see instability in the government. They took 30 years, and the reason is because now the militaries have no power at all. But in Sri Lanka, as you mentioned, they're still in power actually. So I see like kind of impossible to have like justice now, like while still these people are in power. And I think it's a matter of time, like maybe in 10 years more, where like there is a change of government, there is alternation of power, like this can justice, I don't know, take place.
I think you're absolutely right that it does take time, but it doesn't come out of nowhere 2 decades later. And somewhere like Sri Lanka, where there's such divisions and such fundamental disagreements about the truth of what happened and the importance of what happened, it's very possible that if this is just let go now, we won't see anything 2 decades from now. So I think, your point is well taken, and like absolutely, as Vivani has been saying, we have to be cautious about what we can expect in this 18-month time frame. But that's why it's so important for civil society to be doing this work of having these uncomfortable conversations and starting to lay the groundwork for, what, as you say, may well take decades to get to.
And you never, with any of these, I can't think of a single country emerging from a situation, especially with this degree of violence, that has complete accountability. It's just, it's not an option, right? It's too destabilizing. You literally couldn't, think about Rwanda, right? It would have taken 260 years to prosecute everybody at the pace at which they were prosecuting, right? So we have compromises must be made. And one of the ways that some of the international and ad hoc tribunals have done it is they've tried to focus on those most responsible. And so that's kind of a loosey-goosey standard, but it does maybe give some comfort to the rank and file to say, listen, it's not you who we're after here. What we're after is the guy that designed the system, that gave the order, that okayed it all, that exercised command responsibility over units. We want to get at the systemic cause, the architects, rather than the low-level people. Now, in Cambodia, you had this sense of a lot of the sort of top members of the Standing Committee of the Khmer Rouge had died. You had a couple of them that were still alive, and there were people who headed very serious, detention centers in which very serious crimes happened. And so there was a little bit of a fight, and there still is, about whether or not they're most responsible, right? If you're heading a detention center, is that enough, or are we only talking the sort of 12 people around Pol Pot? And in the end, there was one individual already in custody who headed S21, which was one of the big detention centers. So they moved forward against him. When the prosecutor then the international prosecutor turned his attention to these other detention centers, the wall went up. And the government said, no, that's enough. And his co-prosecutor said, no, I'm sorry, I'm not going to authorize this, and the stalemate was reached. So it's not an easy standard to necessarily adjudicate, but that's one way that you can do it, is to focus on those most responsible. And the other way you could do it, we're talking about a 25-year conflict, and so you could limit temporal jurisdiction to kind of 2008, 2009, where you had the white flag incident that you mentioned, where you had the no-fire zones being actually fired upon, where you had some of the most egregious and awful cases. And so that would, in essence, exonerate and give amnesty to crimes that happened 20 years ago, where the evidence is going to be harder to reach, et cetera. But
or it would leave them for the domestic.
Or leave them for the full domestic, and you may have a smattering of cases that go forward where you have evidence.
Can I just another question, very small. Like in the case, there is something that I'm asking about Sri Lanka, because in the case of Argentina, after the democracy come back, people before justice wants stability and wants peace and want okay, let's all be friends, stop this division that caused so much pain. Is is Sri Lanka now in that process, or because in Argentina that was a step before like justice actually, because that's what I think the actual justice took place because this was that step before. Is the same path in Sri Lanka?
I mean, Sri Lanka, we do also polling, so we do surveys, national surveys, and what for the Sri Lankans the most important is education and economic, and that's come out very clearly. And next is actually reconciliation, coexistence, all of that. We did a poll when in March actually, after elections, after the general elections, where we asked, do you think there should be accountability? I mean, look at what's happened in the past. 48% without understanding the debate said, yes, we should. And out of that, more than half said it should have international involvement because of the failures in the domestic system. I mean, those data is available. We are doing another round of the survey to figure out, have those figures change. But largely there is a recognition that you have to have reform, you have to have stability, but also you have to look at some of the root causes of the conflict, without which you're not going to have economic development stability that's going to move forward and have no problems in the future. So it's much more complicated. Just on the military issue, there is, within the military, the conversations we've had, there is recognition there were a few bad apples, and there were some very bad things that happened. If you look at the election results in January and August, from the voting system, from the postal votes, which is from the military, you see the vote coming for change. And there's a recognition that some very bad things happened under the previous regime that has to change. So within the military there are levels, and the foot soldiers will say, look, we were following orders, we had no idea what happened. And it's a conversation to have, because victims will say, we want justice, we want truth. But it's also to explain, look, everything may not be able to go through a special court, but we also have a judiciary that needs to be strengthened that could look at some of these cases. So and it could take 30 years or more, but we need to at least start that process now.
I'd add to that actually that there tends to be a real difference between places where conflict was ethnic in nature or had an ethnic character to it, and somewhere like Argentina, in terms of sort of post-conflict preferences, and with the caveat that victims are not homogenous, and you can generally find a victim that will espouse any position that you might be polling about. But a conflict like Sri Lanka is where there's an ethnic majority and the victim community is mostly from the ethnic minority. Yes, you see the majority saying, yes, we should just move on and everything's fine and let's have development in schools and not worry about the past. And you hear something very different from the victims when you speak to them. And I think that it is a little easier to kind of move everyone towards that place of, it's time to rebuild when there actually is a political system in place that is palatable to all parties. So I was in the room a year ago, or maybe 2 years ago, when Albie Sachs from South Africa came to talk about the value of the South African experience and what the victims got by sort of trading justice for peace. And it was really striking to see the response of Tamil activists in the room, because their reaction was essentially, well, that's fine, but the South African Truth and Reconciliation Commission followed a political solution, and we don't have that here, so we can't begin to think about that. And it was just this kind of total disconnect of where they were coming from, so which for me was kind of very illuminating about kind of what was going on in that context.
Seems like timing and management of timing is probably critical in each of these situations. Like, if you ask for something before the conditions are ready, you get some kind of distorted result, where if you waited a while till the conditions were ready, you would get a better result. But how do you manage it in the meantime, and what do you push for? And do you hold off asking for what you really want until conditions are better. Is there there's probably no answer to that, but
That's what my book is about.
No, but it's true, right? These different mechanisms can be layered, they can be sequenced.
Sequenced, yeah.
There's lots of different ways that you can account for this idea of what is the society ready for.
But who decides that? I mean, you've got a lot of different players.
I wonder whether I could, interesting, I think, what's happening in Indonesia now would indicate that sometimes even 50 years is not long enough to resolve things. My name's Chris Warren, I'm a journalist who was involved in the International Federation of Journalists and was very involved in the situation in Sri Lanka. And I'm interested in the comments here as part of the night program. I was interested you were talking about, you've mainly been talking about the war crimes or crimes from 1983 and at the end of the war. Although you did mention some of the human rights crimes that happened after the war, which were the attacks on human rights activists, and particularly, my concern, is the attacks on journalists that occurred after the time. And I wonder if Bhavani Tiffany might be able to talk a bit about that. So I noticed that there has been some progress in that, with charges in relation to Pradeep, or I'm not sure if there are charges or investigations being made in relation to Pradeep. But there's also the militaries now seem to be pushing back against that overnight. I wonder if you could talk a bit about that.
Shall we take your, I know you've been trying to ask the question as well.
Yes, I kind of have two related questions, and it sort of, I guess, relates to this. So I know in Nuremberg trials, what you had was sort of an attempt to put Nazi society on trial. So you had representatives not just from the military, but from the government, and even from the private sector, et cetera, et cetera. And this was sort of a similar sentiment. So I was involved in the summer doing some interviews, and a couple of journalists asked, or said, you know, it's silly to just put military leaders on trial because the whole society was partially responsible. You should, particularly, she was saying, she was a journalist, that you should put some journalists on trial who were participating in the propaganda. So I'm sort of wondering about, are you only advocating for military leaders and why, and sort of less than like when you think about this like most responsible priority, how do you also think like horizontally about society?
So maybe on the media, just Pradeep Lasanta's case has been, Sri Lanka actually had the highest case of media journalists being killed during the last stage of the war, and even post-war the threats the threats and disappearances resulted in many fleeing. What's happened now are some people coming back because the situation has changed. The investigations, I mean, they're still continuing. I mean, they're still asking for breakthroughs and asking for people to give testimony, both with Pradeep and Lasanta's case. I mean, those two cases, I think, are good examples of how bad the system is in terms. Lasanta's case was in January 2009, where he's a prominent editor who was gunned down in broad daylight in Colombo. Sinhalese, very critical of the government, and actually was very critical of the defense secretary, the president's brother. And Pradeep Edmeligada was disappeared in 2010 after the end of the war, just a few days before the presidential election. And his wife has been very vocal and active in Geneva and across, asking for justice and asking for answers, because this happened after the end of the war. So with both cases, it's really kind of very, very much initial stages, even though it's been more than 5 years with Pradeep and 6 years with Lasanta, and nothing has happened. I mean, they're just still asking for information. With Pradeep's case, they have now identified a military base where he was taken to. And now there is a link to the military. Where it goes from there is going to be interesting to see. With other cases also, there's been military individuals who've been now named and targeted, like named within criminal justice investigations. So this is an interesting time to see actually, can those openings actually follow through with justice in the normal cases. This is not the special court we're talking about. This is within the penal code, whether there can be accountability. This year actually was also interesting. We've had, after one conviction of killing of 11 individuals in the north. After 11 years, that case happened in the north. So finally we see some breakthroughs, but I'm not saying it's all going to lead to conviction. So we'll have to see on media freedom and all of that, whether it improves. At least people can write critically. That's a big step. On accountability and, you know, who do you hold account, one of the points I forgot to raise is the fact that there, you know, one part of one group in the war, the LTT, how do you hold them to account? Because they were defeated, they were killed. And that's a big question, you know, because there's evidence and there's information now of them committing war crimes and crimes against humanity. And that's something we have to actually have conversations about. There are people outside, but most of the leadership has been killed. There are some who, I mean, there's been one case of a former LTT person who joined the government, who had a position in the previous government, with allegations of child recruitment. And I say allegations where you have to actually go through the due process. I mean, those are solid cases, I think, that can actually go to court, and there can be some accountability for some cases. So it's going to be one of those also challenging things as to certain perpetrators, known perpetrators, are no longer there. And who do you go after then? How do you explain to the families that continue to say, look, I still think my child is alive, or my husband is alive, who saw them surrendering to the government forces, for example, to the foot soldiers, not the army commander or the defense secretary, that the person who took them should be held to account. So those are the difficult things. It's not, for me, it's not really which mechanism or which law, really, it's how you talk to the people and make them understand the next steps.
It is crucial that obviously any mechanism has to look at both sides, or all sides, depending on how you want to look at it. But there is this bizarre situation where, because of the white flag incidents and others, the leadership of the LTT has been killed. And so then you're in a situation of, well, who's the next in line to be held responsible? And so there's a disconnect, or there's an asymmetry between, you know, who you might go after from the government side all the way up to the Rajapaksa family versus whom you have left to go after on the LTE side. And so it's not a perfect, they're not mirror images of each other, even though both sides, as Kate emphasized, you know, committed horrific atrocities.
But I think her question was a little more complicated,
Yeah.
and was kind of raising the issue of whether there are people outside the chain of
Oh,
command
right.
who
That's
play
right.
a part. And
Industrialists, you know,
Yeah.
who else benefited from?
I mean, there's also the question of other governments outside of Sri Lanka and their role in supplying actually both sides of the conflict. And you know, India was actually on the ground with their military, not at the end of the war, but and certainly committed a number of
Who were present, yeah.
So you know, and again, this is something that's common to ethnic conflicts. You know, you often see journalists, members of civil society playing, you know, incitement roles that could technically be the subject of criminal allegations, but I suspect we're a long way from thinking about any of that in Sri Lanka.
I mean, the beauty of some of this is that we've documented certain statements that were said by non-military people who actually went, I mean, we got quite, in Sri Lanka actually, the beauty is we had several who went and defended the government's role during the war in Geneva, for example, saying it's a humanitarian operation, zero civilian casualties. Non-military, I mean, the Attorney General of Sri Lanka went and defended, who should be an independent person. I mean, to also look at those roles, you know, during the war, the person who was heading the peace secretariat saying, you know, there's no problem, we're not shelling those zones. I mean, when we had evidence of schools being shelled, or hospitals being shelled. But we haven't even got to that stage. The good thing is that that information is there, thanks to media and human rights defenders who actually documented and archived some of this information. So it's how you use it is the next
And
question.
the Rwanda Tribunal has good precedent here because they had cases involving military leadership, political leadership, lower level political and military, so burgomeisters that were equivalent to sort of a governor or a mayor potentially, and then heads of tea plantations. And there's a whole media case that emerged. Media personalities, so the equivalent of a sort of radio talk show host, Kindi gets prosecuted for incitement. He was riding on the backs of trucks with megaphones, singing his songs that had inciting language within them. So we've got legal precedent to hold a wider variety. The question is the evidence there, who's the right person, et cetera, and can we get the political will to go after this more broader support network rather than just picking a few scapegoats and sort of focusing on them.
And it's also instructive in that case to look at the Special Court for Sierra Leone and attempts to go beyond just what was sort of the prescribed, these are the three warring factions, and to try to reach beyond to supporters, to peacekeeping units that were actually, shown to be involved in more aggressive moves and not just peacekeeping moves, and that influenced the conflict, but attempts to bring evidence of that in, attempts to go after that as a basis for prosecution were blocked by the international funders of the tribunal. So in that case, if you're looking for international support, you might find, people blocking you, not just from internal politics in Sri Lanka, but from the international community saying, we're not supporting
that's
it,
not what this is
here's
about.
the water's edge.
Yeah.
Yeah, I had a question which is about resources, because one problem with hybrid tribunals have been, the international tribunals are very expensive, so the idea is hybrid tribunals can be a cost-saving measure. Then they end up under-resourced and can't do the job that they were supposed to. Plus, as you indicated, there could be a TRC as well as a tribunal. So then you have the two mechanisms battling each other for resources. So my question is there any indication of what resources are available, or is there an anticipation of prioritizing certain processes over the others?
That's another fear, is prioritizing, which gets priority, and it looks like, from at least what the government seems to indicate, they would prefer to see the TRC at the cost of accountability, because it's just politically convenient as well, and it's less messy, but what we keep saying is that you can't just have truth and not have justice. And that's also to think through. Maybe the TRC starts, but you have to have that accountability mechanism. That said, we also need time to design a mechanism for accountability that doesn't fall into the traps of the past and builds up from lessons from the other countries. In terms of resources, suddenly Sri Lanka is this kind of awful case for everyone to get involved. And my suspicion is there's going to be a lot of donors, agencies, the whole TJ industry coming into Sri Lanka. It's like a business,
It's a whole
and this whole kind of, we had this during the ceasefire and tsunami, everyone just coming in and not knowing what to do. As we've seen this happening, and to also not kind of get into that, to be very clear what's possible at what time, and not kind of take a position, this is more important than the other. So again, it's also mattering, like, where do you go and how, when do you do it, and how do you do it, and who can support certain things. But I think, I'm an idealist in a sense that we can do it all. It's just we're not going to do it in 18 months,
Right,
but at least let's start during the 18 months as to what's possible, and have the right people. The challenge also is that there are people who want to come in and say things the donor community would want, the government would want, political actors. So we also what we're pushing for is an inclusive process in designing this, also choosing the individuals. And I understand Colombia is going through a place where there's a conversation at least. Now in Sri Lanka there's no conversation. We're trying to at least open that conversation to see what's possible. So prioritizing, but also kind of making sure nothing gets dropped in the way.
Prior mechanisms have had the benefit of having UN money. So the Yugoslavia and Rwanda Tribunal as subsidiary bodies, they could pull from assessed contributions. Likewise, East Timor and Kosovo, because they were part of this transitional mechanism that the UN was funding and implementing. But, Special Court for Sierra Leone, no UN money, so it was all done by voluntary contributions. And what that meant was that some of the staff were literally out, hat in hand, asking for money everywhere they could go. And yeah, I mean, it's unseemly at some level. Cambodia is the same sort of way, and they're constantly on the verge of having to shut down. They can't enter into long-term contracts with staff because they don't have the funds necessarily in the bank to pay those contracts, and so it's really been awkward. I mean, Sri Lanka's fortunate in that they're not the Central African Republic in terms of having no resources to be able to put towards this. Lebanon has an interesting formula where Lebanon comes up with about 50%, and the other 50% is borne by the international community, of which a big chunk is borne by us, the United States, because we cared about that tribunal and wanted it to be established. You know, who would be the funders for the Sri Lankan effort, and to what extent would Sri Lanka be willing to accept foreign voluntary contributions? Because of course with that comes some degree of management oversight, interference, et cetera. That's part of what this conversation is going to have to cover.
Yes, Cambodia is set up to be the same way, where it would be 50% from the domestic government, but then they've ended up having to have, you know, Japan fund their contribution every
They've
time.
never, they claim they did because they gave the building, but they've said that every year now.
That building was like an old army
Yeah,
base that
it
they
was
used
empty.
to torture
Yeah.
people like that.
Right, exactly.
It was the worst possible choice
Yeah.
for having.
Two quick questions. One was Sri Lanka was the last few days.
The new-
was the-
But he's the president.
No, but was he the defense secretary? in the last
Acting.
few
He
days?
was, yes,
Acting
he
defense
was acting
minister.
defense minister.
So is there any potential?
That's so interesting.
issue
Well-
there? And the other question is
Yeah.
that, could you talk a bit about the Peru?
Sorry?
The
Peru.
Peru is an example.
Oh, Peru, right, yeah.
So yes, I mean, he's absolutely in the chain of command and potentially criminally liable. And there's a little bit of uncertainty there just because my sense at least is that the Rajapaksas kept things pretty firmly in their own hands, so acting defense minister, while President Rajapaksa was also the Minister of Defense. So it's not clear to me, without looking into it in much more detail than I have, that Sirisena actually would have been in a kind of top command position, but certainly on the basis of, you know, chain of command on paper, he is in it and potentially liable for those actions.
Yeah,
And he was appointed as the president went out of the country.
that's why I posed the question. He was
Yeah.
clearly in command.
Yeah.
He's not a mid-level person.
No. I mean, if you look
So-
at it, he was up there
Yeah.
very much, but did he actually was part of the conversations and decisions? We don't know that. On Peru, I mean, what we're looking at different cases. Peru being, it had a TRC that's much more improved than what we've seen in South Africa. We've also had a person who was involved in the experience, Eduardo Gonzalez, coming in and talking about his experiences in Peru and where civil society came in. He's actually coming again early November to explain what that is, because in Sri Lanka it's like Geneva and hybrid. No one knows beyond the South African experience. So to also say, look, we've had so many other examples which are worth looking at. In a situation where there's been a transition, they've not just the TRC but memorialization, reparations. So Colombia now is the other thing, and to look at the Colombian reparations project, for example, you know, it's huge, but you know, we also have a big case, so is there something we can look at? What Peru I just flagged is as trying to get away from the whole South African, just focus on the South African to see are there lessons in other countries. The other thing is, you know, there are other countries who have done both the tribunal and the TRC. And what are the other things we can learn from cases where they've done both? What are the successes, what are the failures? And the sequencing. So Sierra Leone, I mean, I just learned about East Timor, and to see what are the things we can learn from those as well. So the list is long, and Peru is just one of them.
In terms of the Colombia reparations, who's funding the reparations?
The Colombian?
I think you said Colombia.
Colombia.
Yeah.
The Colombian case?
Who's funding
So
reparations?
that's a national initiative,
Yeah,
and they have the victim. There's a trust. I don't know what it's called, but there's an office that looks at like thousands of cases of reparations, and it's about displacement. It's about land grabs. It's huge, and it's driven, the civil society is very much involved in it. Now we are looking at that to see in Sri Lanka whether what role civil society also can play. But Colombia was very much funded by the Colombians. Sri Lanka, we don't have that kind of resources, so we'll have to also look at external resources. But it's an example we're looking at.
We've used trust funds in the past, and you can take voluntary contributions, but they don't generate a lot,
Yeah.
realistically, so. I have time for one more.
Before Rebecca's going to ask two-part question. First of all, within the new government or within the new political leadership, of course, not just the president, there are others like General Fonseca, who's heavily implicated in charging the Sri Lankan forces through the last years of the war, and is now a prominent member of the government, I suppose, or prominent supporter of the government, at least. How are they handling that in particular? Not just his case, but that general case, that type of case. But the second question is, you talked a bit about how corruption was, in some ways, the war and the repression was a device for plundering, more than it was about political control and its own device. Is there a separate kind of anti-corruption process going on that's effective?
So this government came into office on the promise of good governance and cleaning up the corruption. I mean, that was a big thing. In the 100-day plan President presented, there's nothing on human rights violations. It was about corruption. It was about open transparency and looking at what happened during the previous government and nepotism, all of that. And that's been the key focus. That's still the priority of this government. If they're given a choice, they'll go with that. They will just forget about war crimes, the crimes against humanity, all of that. And on that, they've got several initiatives underway. The Bribery Commission is doing a lot of investigations. That's an existing initiative. They have a new entity called the Financial Crimes Division, which comes within the Prime Minister's office, and that's what's looked into some of the cases involving the Rajapaksa family. So even, I think, yesterday or today actually, the former president was brought in for questioning on some of the corruption cases. So the family on a regular basis is brought before for questioning. Only one member of the former family has been arrested, that's the brother, Basil Rajapaksa, and he's on bail now. And there's frustration among some people saying that's all going very slow. I come back on the whole point is there has to be due process. You can't do the same things the Rajapaksas did. And you need time for investigations to build up the case. But it looks like they're putting a lot of attention, energy, resources into the corruption cases. And there's quite a lot to deal with. So for the other cases can easily get sidelined in that process. On the issue of Fonseca and others, I mean, Fonseca is the most well-known, but there were other high-level military generals involved. Fonseca, interestingly, lost the parliamentary elections. He couldn't get more than 2,000 votes, which was also an indicator that he thought he was very popular, but he didn't get the votes. And it was also political dynamics there. But there are others who are still in military, there are a lot of allegations, and the question is, how would they be looked into? One was promoted as the second highest military person in the army by President Sri Lanka. And as civil society, we said, look, where is the vetting that you have promised? Because the government has promised vetting, but they're not implementing it. So it was an indicator that they promised, but they might not follow through or understand how to follow through. And that's a huge thing to also see is when there are allegations and there are people still within the military or retired who are very popular, how are you going to bring in cases or whether those cases will be initiated? There are cases where some of them have been in overseas places and had to leave because of pressure by international groups like the Jagat Dice case, for example, where he had to leave Germany because there was a possibility of an investigation in Switzerland happening. Now, those are interesting ways of putting pressure on those individuals as well. So it can be different ways of keeping the pressure and pursuing accountability. If that answers the question.
Well, thank you so much to our wonderful panel and to all of you for great participation. It's wonderful having you here.